guys. Just give me a moment. Just give me a moment.
Okay. So I think we can kick off. It's 3:30, so we start right on time, and we have a number of participants with us. So if you, Ashish sir and Anurag sir, allow me, I then proceed with the session.
We are ready.
Yeah,
yeah,
you are ready.
We can start.
We can start. So good afternoon, everyone. My name is Hanna Onderkova. I'm head of IP at the EBTC, ACA European Business and Technology Center. And in this context, we are very happy to be here and collaborate with the Marathwada for Growth and Incubation Council, which has launched the first of a kind virtual pavilion and CIA's ICONN2021. I have been excited to be part of the session because EBTC as an organization has been working and reaching out to Indian startups and SMEs for quite some time, so also with help of Magic. This is not the first session. So the topic of the session is IP due diligence, because as all of you know, that's why you're here. IP is a very important aspect. But before I go any further, and we start talking about the topic in depth, I would like to invite Ashish sir to give us a quick introduction and quick keynote. Sir, over to you.
Yeah, thank you, Hannah. It is indeed a pleasure to interact with you on this platform. Most of you know that Chamber of Marathwada Industries and Agriculture, CMIA, has promoted MAGIC, and through this incubator and SME accelerator, we are right now conducting one virtual exhibition which is on for almost 3 months at a stretch, wherein startup ecosystem players are getting opportunity to showcase their product and services, especially during this pandemic situation. And as part of this virtual exhibition, wherein we have partnered with Tata Technologies as part of their CSR initiative, we are supporting student-led startups from Tier 2 and Tier 3 cities, and giving them exposure to various facets of startups, especially like the intellectual property rights, like what it takes to file a patent and other things. So today's session is first such session in collaboration with EBTC. We are planning to have 5 such sessions in the immediate near future, and I'm sure these virtual interactions on specific subject would be of immense importance and value to all those who are connected with startup ecosystem, and especially those who are exploring business opportunity with European countries. So this particular session and the series is dedicated for promoting business with European countries, and I'm sure each session would be very important, and we have got very distinguished speakers lined up for the next 5 sessions. And I thank EBTC for taking this special effort. And I also thank CII team for supporting us right through and through for all these initiatives, especially the team of Anurag and his colleagues who are like virtually supporting us round the clock. So any issue a little bit also is getting addressed instantly, and I thank CII team for that, and look forward to a very enriching discussion and conversation ahead. Thank you.
Thank you. Thank you, sir. Anurag, you want to say a few words from the CII side before we go any further?
Just that we are really thankful to the Tata, the TMIH team, and they have been a very cooperative team. We have been closely working with them, There are a few more sessions that are lined up, and I would request you to please take the session forward, please. Thank you.
Cool. Thank you very much. So I just shared my screen to for a quick with a quick presentation, which will be as a skeleton to this session. If I can share it, just allow me a moment. Yeah, there we are. Right. I hope you all can see my screen.
Yes, please.
Yeah. So as I said earlier, and it was mentioned here earlier, you know, IPR these days, particularly for yourself as a small companies which are about to, you know, make it big worldwide. I'm sure this is dream to all of you. But before you do that, you of course have a lot of things to think about. You know, where you get your funding, you know, obviously what you do, get expertise in your field, etc., etc. And IPR is a very important aspect of what you have to consider if you are to be a successful startup, scale up, and then large company. And I'm really happy to have a speaker with me from Sagesh's IP. They have been working also with us for many years. And Tanmay, you know, with his many years experience in the field, will be somebody who I will be questioning about this session. Here's a quick series of Tanmay. I'm not going to reiterate it. You all can read it. And I'm really happy that he joined us for this session and, you know, give you some sort of insight from the practical experience of his dealing with both European and Indian or actually worldwide clients. So Tanmay, welcome. I hope we can
Thank you,
hear you
Anna.
and see you.
Thank you, Anna.
Cool. You're very welcome. So
Please go easy on me.
I think,
don't.
yeah, I'll
don't
try
ask
to go
me.
easy on you. So I think people would definitely, you know, because we all know when we talk about IP, we think, you know, patent, trademark, and you know, industrial designs and whatnot. But when we look at the IP diligence, you know, can you explain to our participants in layman terms what it actually IP diligence stands for? What does it mean?
So, I mean, in common parlance, people refer IP due diligence as an audit of IP assets owned or licensed by a company, both ways. So this means checking or verifying the ownership of IP, auditing that if all the fees is paid or not. I mean, then, you know, looking that if patents are valid or not. How are the usage rights being done? I mean, evaluating the potential of any infringement or any risks that might be there, any liabilities that might be there. So this all comes under IP due diligence. I mean, I know this sounds a bit very legal to understand, but you know, simply put, for everyone's understanding, a due diligence is an investigation. It's an audit, and it's done to confirm the facts or details of a particular matter. Over here, we can just add IP to it, so it's IP due diligence.
And since I guess many of us, our companies will be, you know, small startups or, you know, small businesses which are just getting foot in it, and they might not have any IP rights as of now. Would you say that IP diligence can be also conducting prior arts, trademark searches, and this type of exercises where they can find out, you know, how to name their company or the product or what sort of logo they should design? Is that also part of this IP diligence?
So very well said, Hannah. I was about to also mention that you know, listening to all this, it seems that it is only applicable for organizations that have IP, and that might not be the right way to perceive it. I mean, you can extend it further. So, for example, if a company is seeking investment, specifically for startups or for our small and medium businesses, or maybe for large clients as well, if a company is seeking investment or maybe planning to collaborate with a firm in Europe, do some tech transfer there, or maybe not collaborate but launch a product into that geography. At all these stages, you know, IP due diligence is must, because they must be well aware of how well their IP can protect them if they have IP. If they do not have IP, then what are the risks in the geography that they are planning to go? or if they're getting into a deal with someone, be it a merger or a tech transfer, what is their strength? I mean, be it in protectable assets that they have not yet protected, because due diligence will cover both the aspects, or the already protected assets as well as protectable assets, but were ignored or were not protected so far. So, adding to what you said, yes, there is a opportunity for everyone to go beyond the legal definition of IP due diligence, look for the marks or the ways to protect their brand, and then safeguard them, register them. On a holistic level, they must know all the active IPs that are there, what are the protectable areas that should be there, and also the infringement risks, if they are getting into something. I think I can just cite a quick example, maybe that might help to understand it better, or stress on the importance of IP due diligence. And I'm using the examples of Rolls-Royce and Volkswagen. Some example that I've already discussed with you earlier also in my sessions, because this is something which is a clear case of IP due diligence at its best. So this deal was done in 1998 when Volkswagen purchased assets of Rolls-Royce and Bentley, and this was somewhere around $900 million. But Volkswagen did not realize until after closing the deal that the IP assets in that deal, specifically the trademark Rolls-Royce, was only available for them for a limited period of time, 5 years. And then it had to go back to BMW, which was a deal done previous to this agreement. So essentially what happened, Volkswagen spent a lot of money where they could manufacture a Rolls-Royce, but they cannot sell it as a Rolls-Royce because they will not be having the trademark for that. And then eventually after 5 years, BMW finally became the Rolls-Royce owner in 2003 and the exclusive manufacturer of Rolls-Royce, and Volkswagen only had the rights for Bentley cars. So over here, if the IP due diligence was done well, and people would have seen this coming if they would have looked at it from that perspective. So yeah, I think that maybe explains it. Yes, no, Anna?
Yeah, I think it's very, very interesting. I would also add to that because I do work a lot with, European SMEs and startups. And sometimes also for them, when you're just about to come in the market with your product, they can make the decisions whether, that particular asset, the technology can be also protected as a trademark, as a trade secret, or whether as a patent. Yes. So I think it's a kind of, in a different layman also ways to say, when you have your, be it invention, be your product, be your service, just look at it, how you can protect it, in what way, and we are, because obviously these examples are very, are great, but they're for big corporation, and sometimes maybe a smaller organization find difficult to relate to it. So since we speak about the small organizations, do you think that they can do IP diligence on their own?
A motivating answer is yes, but the conditions that apply over here is that they should have someone in-house who has prior experience of doing this. Generally, if you have an in-house IP team or a legal team which has experience on IP, then they can do it. From legality perspective, we would need an expert. I mean, who knows about IP laws, patent laws, because IP is territorial. For every jurisdiction, their term may change, or their protection scope may change, their prosecution may change, and the ownership rights may change. So yes, the person should have that knowledge. And then if we are specifically talking about patents, then we would need a person with technical background who understands the technology. So, he can look at the validity of the patents, or while performing a freedom to operate search, he would be able to, understand the claims better from the technology side and see, or confirm if they are infringing on something, or would there be any infringement possible or not.
And I would also think that if we have, let's say, startup or small SMEs, which are not so, they still don't know that much about IP, having a, you know, third person perspective, you know, to talk about it would of course give them different point of view, something they might maybe not have thought about before. So I guess it's always to, you know, worth, you know, having a consultant talk to somebody
Yes.
else about it and get some advice.
Definitely,
Yeah.
definitely. I would say that in case you do not have that expertise or experience, then it is advisable to get somebody on board, maybe a consultant or hire a firm, because IP due diligence is a very important aspect that plays key role in, many things. Either you are getting into a deal with someone, you are raising funds, you are mortgaging, you're looking for raising funds through mortgaging your IP. So on all the business level things, IP due diligence will play an important role, and getting it done from experienced professionals is needed.
Yeah. So no jugaad.
No, Jugaad. Yeah. If you can do it in-house, fine. I mean, you should have a person who has that knowledge from the legal side as well as from the technology side.
Yeah. So when we look at that process, you know, what is typically the process of the IP due diligence, and what would be the outcome of such activity? I mean, is it a report, or is it like a, you know, series of suggestions, or how does it actually work?
I believe this question would need a separate session altogether. This this would be a long discussion, but let me just give few pointers so that, if people are trying to figure out a way to do it in-house, or maybe, experience doing something in-house, then they can go ahead. So the first and the foremost thing in the process is to know the company that on which you are doing IP due diligence. That is the first and the foremost. You should understand what are the businesses of that company. Are there any subsidiaries, or do they have any partnerships or tie-ups or joint ventures with organizations abroad? Because when we have such an arrangement, then the ownership of intellectual property becomes questionable, and we have to be very sure about it. So the first step is knowing the organization so that you can be sure about the ownership of the IP. Then the second step would be, once you're knowing the organization, you should be in a position to understand what are the intangible assets of the organization, and are those assets protected or not protected. So in some of the cases, there might be assets which are protectable, but because of no knowledge, they might have been missed or not protected. So for example, organizations would go protecting a trademark in India, and they might feel that, with that trademark, they can launch a similar brand or a product in US, but that might not be the case because IP is territorial. So even though you have a trademark in India, you'll have to apply for a trademark in US. And then if your trademark is a logo, then somebody can tell you that, you should go for a copyright on the logo as well. So from that perspective, knowing what is protected and what is protectable is important so that you can take necessary steps. Then, also understanding the validity of the existing IP, that is also important. So in case you have few patents that you have filed as a startup, and say you have filed them only in India. Now you are planning to, sell that product in Europe. So since IP is territorial, then the patent filed in India cannot support you in Europe. So you'll have to either take a PCT route to file it if you still have that time, or do a direct filing, whichever way you want. You can expand it over there. And in case that timeline is fast, then you should be in a position to identify similar IPs in that geography and make some deals with them, licensing deals with them, so that you can launch the product easily. Also, in some of the cases, it might be the case that you are raising funds and you have a patent at hand, but that patent has only 4 years left on the term. So understanding the term of your IP is also very important. So patents generally go for 20 years in most of the geographies, while trademarks are perpetual. I mean, after every 10 years, you can renew them. They can go for lifetime. Copyrights, by virtue of Berne Convention, it is applicable globally, and also it has a life of 60 to 65 years after the creator. So I mean, with different IPs, there's a different term in different geographies, and that has to be assessed, be it a protected idea or be it a protectable idea.
So I think if I sum up to what you have been saying, basically, when we look at the diligence in terms of obviously what you have, but also in kind of taking into consideration where you want to go in the future. So if you want to go into particular market, particular jurisdiction, so this is something which you have to also check, and particular for the small startups, or maybe some of you are not so small anymore, but you might have vision in the future which markets you would want to enter, so then you have to consider it as well. So now, of course,
and
please.
And sorry, I interrupted because this was important and I wanted to highlight it. And it is very important to be aware of the timelines, because a lot of times I've seen startups coming to me saying that they would want to take their patent to US, but they have already lapsed the 12-month window of doing that. And then they are at a loss. So being aware of those timelines is also important if you're planning a strategy to go abroad.
Yes, and I would also add to that, since you mentioned it, because I have very similar experience with European companies which would have products and they already publish them, or they start manufacturing them. So the moment you put your invention product, the particular for patents and industrial design, you put it out, then you pretty much lose the possibility to file for your IPR. So this is something also important to consider for whatever you have developing right now, that before you let it out anywhere, you have to protect it. So that's important.
So from the due diligence perspective, Hannah, the protectable thing, it covers that, because once you get to know the company, then you would identify what are the areas which need protection or are protectable, and then you'll have to make sure that you just don't go out in the media and talk about the product or start making disclosures about the product. It's always advisable to get it protected first and then go out and talk about this. Very, very well highlighted, Hannah. Very well highlighted.
And I would also say, add to one more point to it, because this is again something which I come across quite a lot. When you look for international partners or you look for collaboration partners, and you have your ideas, always make sure that again, before you disclose anything to anybody, you sign your non-disclosure agreements. Obviously, as Tanmay said, you file your IPR. So be really always on the cautious side, because it's always better to be safe than sorry. And isn't it? So that's on that. And I'm sure that a lot of our participants, they are probably kind of curious, okay, I maybe want to hire somebody to help me out because I don't have the expertise. So now the big question is, how much does it cost?
Well, so I mentioned a lot of steps that are there in doing it. So, in case only one step looks important, considering the present scenario of the organization, then you can go ahead and get it done for as low as $300, maybe, getting. So let me make it case by case basis, give you some examples that will bring more clarity. So for example, if there is a company and they are trying to launch, say, a product in Europe, an Indian startup trying to launch a product in Europe. So from the IP due diligence side, what is needed? The first thing is, does he have enough protection to launch that product in Europe? Second, are there any infringement risks for him when he's launching that product in Europe? So from the first perspective, a quick audit can be done to see what sort of patents, trademarks do they have in place, and if those are applicable in Europe as well, have they been extended to Europe as well? And then on the second phase side, we can do a quick freedom to operate search. So the first aspect of it would not cost more than, say, $100 or something, because it's a quick audit. I mean, I'm assuming that for a startup, they would have a portfolio of, say, 10 or 20 odd patents, or 50 odd trademarks. So doing a quick audit would not charge them much, $150. But when we are going for freedom to operate analysis, that might cost a bit more, because we'll have to look at specific geographies that they're planning to launch, or what sort of key features are there, how elaborate is the product, what is the novelty in the product that they are trying to check for infringement risks. So all those things might, but still that might range somewhere around $500 to $1,200 or $1,500. A customized quote can be there. And for an entire study, I think it might go a bit higher, a lot higher, I would say.
I would say to that, because generally, when people hear the cost, in their eyes think, oh God, it's too much. But I would kind of back you up on that, because we know it's not just about the, infringement risks for yourself, but also that you don't end up, unintentionally infringing elsewhere, so, and obviously then, the cost of the infringement suit, you might think you have a great idea, but somebody in Germany might have equally great idea. So it's to also protect yourself. So when I speak to young people or, small organization, I always tell them they should see IPR as an investment.
Yes.
Something which they could monetize in the future, but something which will help them to, not to be in trouble. So irrespective of the money you might have to put it initially, it will always be to your benefit.
Yes,
So,
yes.
yeah.
And with all these things in place where the entire economy is technology driven these days. I mean, everything that we interact with in a day-to-day basis, be it a product, be it a technology, be it a device, everything is technology driven and every technology is protected. So why to miss out on that? In case you have something which is really good, any idea or invention that can change the world, why not go ahead and protect it so that nobody else can steal it? And in case you want to go for other geographies, be prepared.
Yeah.
Let's not go there unprepared.
Yeah,
and
that's true.
Yeah.
I would also add to it for some of our, participants, if this is a interest, because obviously I understand that, filing IPR, particularly in a Western world, it's rather costly. There are schemes. I don't know whether the other session, which will be here, will be also access to finance, and there will be, I believe, in the future as well. For example, Mighty Startup Hub, they also have initiative to support, to pay for the IPR. I don't know whether Magic has some such initiative. So also look for these initiatives which would reimburse you for the intellectual rights abroad, also in India, I think, as a matter of fact, to be kind of make sure that you have, sufficient, you find the money to file for your IP, because, I give you example, if you file in Europe, it goes into thousands of euros, so which can be beyond the means of the Indian startups or small SMEs. But having said that, there might be ways how to help you somewhere on the way, so you don't have to cut the corners on the due diligence parts. So before we go to questions, because we are, it was very interesting discussion, so we are slowly running out of time. So is your, last kind of question of the day, what would be your suggestions? Because of course you have been, working with companies for so long, so I'm sure you have a few pointers you can share, which you haven't mentioned yet.
I think you have mostly covered it, Hannah, but so if I can just put down some points. So IP is important. You stressed on it, and everyone knows that IP is important. It's an investment. It's very important these years because of technology-driven economy. Then, very important thing is that people only feel that IP is an expense, but actually, it can be a source of an additional source of revenue for you through licensing or through monetizing your IP. And due diligence will also help you there to get some strong IPs in your place. So it is an additional source of revenue for you. Look at it like this: you are growing that business also. I mean, so we have Dolby. I'm pretty sure nobody has seen a product from Dolby. Like there are speakers of Dolby or there is a TV of Dolby. No, Dolby has just the technology which it licenses to all the TV manufacturers, headphone manufacturers, or music manufacturers around the world. And their entire business is built on that revenue that they get from licensing, the trademark that they have, and the technology they have. So think this from that perspective, that it's an additional source of revenue for you. Also, we should not have any loose ends. So I understand and I respect the enthusiasm with which we come up with ideas, and we see that they are revolutionary and would change the world. But somebody in some other corner of the world might have also come up with that spark of genius, maybe at a similar time or maybe before you, or anything might have happened. So please don't go out unprepared.
Yeah, that's very well said. Thank you, Tanmay. I think it was an interesting session, and we have now a few minutes for the questions. There is a question from Sahana. And please, all of you, if you feel, because we have as of now just one question, if you want to ask something, please do so. This is a great opportunity. We have such experienced expert here, so he'll be very happy to share his thoughts with you. So do not hesitate and give us a shout. So first question from Sahana, and then we have another question coming up. So she's asking, or he's asking, not sure, sorry about that. If I'm manufacturing a device in India and I hold IP in India, when I want to export the product to Europe, US, is an IP requirement to be filed in Europe and US also?
Okay, so if you are exporting, I would say that let's take it as an example. Say the name of your company is Apple, and you have a patent in India. Now, if you are selling your device or you are exporting your device to Europe, are you selling it by the name of Apple, or is there an importer who is just buying product from you and then labeling it by his brand name and selling it by his brand name? What is the scenario? Because you are exporting is very open-ended. Are you selling there by your name, or is somebody else selling the product that you are exporting there?
So we might have to wait for answer from Sahana on that. And by the time we get back from her, it's a female, Indian female name, no? Sahana. It's the female
Yes.
name, yeah, from Sahana. So then we have two more. Please elaborate considering two cases. So I think she wants to know more if somebody else brands their product in US or if they export it in their own name.
Okay, so from the first case perspective, that you are selling it by your name only, then you'll have to check for infringements. Even if you do not have IP in that geography, but you'll have to be very sure that you are not infringing on somebody else's IP. So that is step one. This will help you easily sell your product without getting into a lawsuit. Now, the second aspect of it is that stopping others from copying your product. For that scenario, you should have an IP in Europe. Otherwise, anybody can buy a product, reverse engineer it, and start selling it, and there would be no IP to stop him. So I hope that makes sense for the first use case. Then from the second use case, where somebody is importing the product from you and he's selling by his own name, then the liabilities would be shared between both of you. So you will have to understand what all parts are you selling to that importer, and in that entire assembly, what all parts does the importer own. So you will have only the ownership of the part that you are giving to the importer, and also in case importer is not selling it by your name but on his name only, then he'll have to make sure that he has done an infringement check and there is no infringement.
I don't know whether we lost Tanmay or yeah. Okay, more questions. Sahana, I hope that I answer your questions. I just see there was one more question from Sridhar Krishna. If I make an innovative product in biotechnology space, product from living organism, are they qualified to be patented? And if so, how?
I would not be able to give a very straightforward answer to it, but your question is valid. So yeah, we do have patent protection for plant varieties where things the new advances that we are doing in hybrid things like hybrid seeds or hybrid plant things, they have a scope of getting protected. But still, I'm not an expert on this, to be honest. I would request you to speak with a person who has the relevant experience in such applications and the protection on this. I can tell you from a general holistic perspective that anything that is novel and gets any technical advantage, solves a problem, and unobvious can be protected through a patent. For organisms and living things, we have a separate thing called Plant Varieties Act protection. So you might want to check that.
Also, I think since there is always question, when are you looking at only India, are you looking abroad? If you are looking abroad, because as you might know, some of you, if you want to file IPR outside of India without the prior filing, you have to ask for the permission. So there are a little bit more complexities if you know, you don't want to file in the IPR first, let's say maybe if you want to go abroad directly. So, and that's why I think it's very important, you know, to have this chat with the expert for your IP due diligence, you know, and align this IPR strategy or this IPR plans with your business strategy, what you want to do, how much money you have, where you can get the money from. But yeah, protect yourself, because it's, as we said earlier, always better to be safe than sorry. There was another question from Mahalakshmi Srivasan. Hi, I have the technology valuation available. Could I get the patent valuations done for these technologies, and how different it must be from the technology valuations?
Okay, so if I'm understanding your question correctly, then you have looked at a particular technology and seen the scope of that technology. I mean, how can that technology be valued, or what would be the value of this technology going forward? And now you are thinking of getting the patents in that domain or in that technology valuated, right? And see what is the actual value or monetary value of that patent. I hope I'm correct. I'm assuming that and answering from that perspective. So, so for a patent valuation, you would need to check from all the perspectives, the market side as well, the technology age as well. How mature is the technology? How you know, how well adopted is the technology or accepted? I would say, and based on that and other 16, 17 odd parameters, you would get an analytical valuation of your patent. So it would include IP things as well as market things. IP things would be like, you know, claim length, remaining life of the patent, you know, so on and so forth, number of prosecutions there, number of citations there. And then on the market side, it would be the technology valuations, the market size, the opportunity size, and all those things. Combining both these, you can ascertain a amount or a monetary value to your patent. I hope that was the question. Hannah, any points from you on this? I hope I assumed right and then answered it.
Yeah, it looks like it from the question. I think that needs maybe more kind of discussion. There is so Mahalakshmi is asking, I mean, I wanted to know valuation of patent. You know, this is a separate topic altogether. It's not really that much IP due diligence topic. Maybe you could connect with Tanmay on it separately, because again, you know, goes to different topic. Always have few minutes, so I'm sure Tanmay can quickly drop his email to the chat, and you can kind of touch base with him on that. Because this goes a little bit, yeah, it's, you know, it's a little bit a different topic. There are two people raising hands. Mr. Harsh Sethi, I know he asked the question. Yeah. So Mr. Harsh, are you asking about the PCT filing? Though it's also not really IP due diligence question. It might be considering, you know, if there is certain markets you don't want to. Issues and advantages of PCT filing. Tanmay, you want to go on that, or should I give a few thoughts and you just kind of add to it?
Yes, Hannah, please go ahead. No problem.
So from my personal experience, and I'm sure that it's gonna be it's obviously in more country you have a search report and whatnot. And also it will save you some type of cost as opposed to doing it, you know, jurisdiction by jurisdictions. But I think most importantly, it would give you time. You know, you would have 31 months to decide in which countries you want to go. So you get around you know, close to 2.5, 3 years, whatever it's to decide, you know, where you want to file your application. So let's say you do a priority in India, then you file a PCT application. So it gives you sufficient time to, you know, launch your product in India, become a little bit more established, and so on. And then you align that with your business goals. And you know, you then want to go to Germany, or you want to go to US, or you want to go whatever, and then you can accordingly file the application. So that I see would be the major advantage. advantage, because if you go back on, conventional application, you have to file the application within a year. So, you file your priority, and then within a year, you have to file everywhere else. Now you look at EPO, if you file application in EPO, it would cost you before the filing to the grant close to 10,000 euro. So you need to be very much sure you want to go there. You have a business in the jurisdiction before you spend, how much is your 80 rupees right now, right? Before you spend 80 lakhs. So this is about that. So the PCT
8 lakhs, Hannah.
80 lakhs, yeah, okay.
8, not
8,
80.
okay, oh, sorry.
80 would be too big a number.
It's sufficient time and you would still have your priority. So that I would see the benefit of the PCT. I don't know, Tanmay, what would be your thought on PCT filings?
No, I align with it completely. PCT is essential if you need time to decide where you want to file.
Yeah.
If you're sure from day one, go ahead, file through the conventional route. But if you want to see if the technology is maturing as per your expectations, if the idea that you have protected would have value in the future, then go ahead with the PCT route. Spend time looking at how the area matures, how the technology matures, and then if needed, go ahead and file in other countries. Even if you feel after 3 years then that it is not needed, then it's a very small investment, especially from India. From India, if you're taking the PCT route, it's a very small, but it will give you enough time to think and decide before you take a rash.
Yeah, and especially if you had your patent, the ICR, the first examination report done by the Indian Patent Office, I think it's like what, $100, something like that. So it's really, really cheap in comparison to having your search done, by the different patent offices. So that I'm sure the Indian, companies have that advantage of choosing India as the search authority that way.
Yes.
So there was, we have a lot of questions. I'm really happy, that people are so interested to, having this interactive session. And I think if there is more interest from you, do get in touch with us. And I'm sure with Ashish and CAI, we can organize more sessions for you on various topics. This was like a first one which we wanted to do, and I'm really happy that there is such an interest. So please do get in touch with us. Because I just put the last page because we are pretty much at the end. So you see my email here with a typo mistake on
And
their
Hannah, And Anna, you have been a great host. I mean, the way you have explained things. And
thank you very much. I think we are running out of time. I would ask like more. I know we have 3 more minutes, so we'll ask one more presentation. One more question. Sorry, that was. Does your company also protect against infringement if we file IP in your company? That's the court. But I'm sure Sagesh's IP could help you with advice, and they could help you with filings, and they could help you with the due diligence. So I think Tanma, you shared your CV, you shared your email there, so they can get touch. But generally, do get touch with us either through CI platform or for me directly. There is a typo in my email. I'm Onderkova, ONDRKOVA. This is when you have a very long foreigner name and you ask my Indian colleagues to prepare it. So at EBTC.eu, and do share if you have any topic of interest which some of you would like to hear more. I'm sure we would love to organize some kind of session like this for 45 minutes, interactive, where we can share ideas, or where we can have some open session as well to kind of have chat with you, some of you. So I think maybe Ashish, sir, you want to add to anything before we wrap up, because it has been 45 minutes. Time went like this. So if you have some last thoughts before we go.
No, I would just like to thank Tanmay and you for having this conversation in such a lively way and answering to so many questions from the audience. And I'm sure audience definitely got the information and the details that they were looking for. And I'm sure in our next session also, they would be there participating next week, because every Thursday we have planned such sessions with EBTC, and all such sessions are very informative, very useful. Do join for the next session. That's what I can say as of now.
Yes, yes, we have access to finance, we have another trademarks and branding. There's quite a few different topics, taxation, I think, is there as well, so we wanted to do it across the different fields or different, interests, because we understand that not everybody is keen on IP only, that IP is obviously aspect to consider when you want to build up your company, but it's not the only aspect to consider. So yes, so that's all for me. Thank you very much to all of you. We have 48 participants. This is a great number, and we will be definitely looking forward to seeing all of you at the other sessions. And as I said, except for what is already planned, if there was an particular interest, do write to us and we can see what we can do. Otherwise, I'm sure Tam, I can say, follow EBTC. We generally organize a lot of different sessions or IP topics. I'm sure Sagesh is IP as well. They are very active in the webinars, so whoever wants to learn more will have a lot of opportunities. So I promise that's all from me. Can go on forever, woman talks a lot. So I wish everybody a nice rest of the day and looking forward to seeing you soon.
Thank you everyone.
Bye.
Bye.
Thank you.